Okay, well, welcome back, everyone. In an effort to keep us on schedule, I'm going to kick off our third presentation of today's session, which, as I just mentioned, is going to focus on political speech in the workplace. And I'd like to welcome in Christina Jepson. Christina is a shareholder in the firm's Salt Lake City office and has been practicing a full spectrum of employment law matters as well as employment litigation for more than 25 years. If you have any questions during Christina's presentation, please feel free to submit them via chat. We'll do our best to address your questions. If not, please feel free to reach out to Christina directly at the end of her presentation, and she'd be happy to address any questions or concerns that you may have. So with that, Christina, I'm going to turn the time over to you. Thank you for joining us today.
Great. Thank you, Jason. So as mentioned, my name is Christina Jepson. I've been at the law firm for 26 years and used to be the chair of the employment department for about 10 years, and more recently have taken on the role of director of diversity, equity, and inclusion in addition to still practicing law. So very interested in issues about diversity and equity and how those intersect with other employment issues that we deal with. So unless you've been living under a rock, you probably know that politics has been a pretty big issue in our country for a while and has been a big issue in the workplace. And more and more is seeping into the workplace, and we're all having to try to figure out, how to navigate that. So that's what we're going to be talking about today. So when we talk about political speech in the workplace, it's really this tension between, on the one hand, the employer, which probably most of you are here on behalf of an employer. An employer wants to control its workplace, control its image, right? To make sure that its image is what it wants projected to the public. And on the other hand, we have employees who many times have different interests. They want to make their own choices. They may want to engage in political expression, which the employer may or may not agree with. And they want to have the employer have, less control over them. They want to have their right to do what they want. So, in recent years, even though this has always been an issue, in recent years, it's been more so, I would say, because of elections, some pretty heated elections. There have been a number of protests. The uptick in the Black Lives Matters movement has brought some of these issues to the forefront. There have been, there's cancel culture, which we'll talk about. And right now, as we speak, masks and vaccines are big political issues that are, part of the workplace and going to even be more part of the workplace when the OSHA guidelines roll out about mandatory vaccines. So I kind of like to think of it this way. I like to think of the work life versus the public life versus the private life. And at the work life level, the employer has the most right and ability to tell the employee what they can do. They have some right in the public sphere and probably the least right in the employee's private sphere. So what do I mean by that? Well, so the work life, you can go back, Jason, one more. So in the work life, what I'm really talking about is, if your employee is at work in your workspace, or they're on your email, or they're on your social media platforms, then they're at work and you have a lot of right to tell them what they can do or not do. We'll talk about some limitations on that today, but obviously you have more interest in doing that and you have more right to do so. And then let's kind of think about the next sphere, which is maybe the employee's not at work. They're at home, they're on their own social media, but say it's completely public. Their social media account is completely public. Maybe it's a Twitter account, and they make some post that is seen by the whole public. They're not at work, but what they're saying out there could impact you as an employer. If people know they work for you, maybe their social media account even says they work for you, again, you might have some interest in impacting what they do there. And then we have sort of the private life, which probably used to be more private than it is now. And so, think about an employee just, in their own private world, having a conversation with someone about their political beliefs. And, we would think in the past, the employer probably has very little interest in controlling that and probably very little right in controlling that. But public and private is a little squishier these days, right? If I'm literally in my living room just having a conversation with a couple of friends, that's unlikely to be known to the world. That's probably going to stay pretty private. But if I'm making a post on Facebook or Twitter about, about something political, about my opinion about something, and even if I just keep that to my friends, if I have 500 friends and they have friends, it's hard to say that that's really private. I'm putting it out there in a pretty big format. So the private world, we have to think about, really how private it is. All right. So as we kind of keep those kind of concepts in mind, let's go on and talk about how this might come up for an employer. Why might an employer care about an employee's political speech or political activity? One thing that obviously has happened a lot in the last number of years is what we call the cancel culture or the cancel movement. And it's really this concept that some group of people out there may not like what you're doing as a company or what a particular employee is doing, and they might try to cancel them. And if they try to cancel an employee, that could include finding out where the employee works and putting pressure on the employee's company to get rid of them. So say someone goes out and takes some position on abortion, one way or the other, and there's some group out there that doesn't like what that employee is saying, and they go to their social media accounts or look on LinkedIn and see where that person works, and then they find out they work for you, and they come to you and say, you should cancel this person, you should fire them because they're doing something that we think is improper. So that's happening a lot, and employers have to respond to that. So we'll think about that a little bit as we're talking about these different examples. Even if it's not necessarily a cancel, an employee's conduct, their political speech, their political activity could lead to public scrutiny. It could make customers upset. There could just be a lot of scrutiny about it, and that could be a problem for an employer as well. And then, of course, there's the more obvious situation, which is an employee is talking about politics, political views, and it causes some disruption in the workplace, or it's offensive in the workplace. It's causing some problems for other people in the workplace. So that can also come up as well. All right, so I like to talk about, does an employee have freedom of speech? Because you do hear from employees quite a bit that they have freedom of speech. You hear that from people in the public. They think they sort of have this unfettered right to speech, and that's not exactly right. Many of you are lawyers, and other of you, I'm sure, have looked at the Constitution, and so when we look at that, if we go forward, I like to keep a little pocket Constitution in my purse, which my kids think is really funny, but it's good to read this once in a while and see what it says. So if we advance the slide, we're going to look at what does the First Amendment actually say. And it says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, press, right of assembly, those sort of things. Now, if you look at that, what it says is Congress. It does not say employers. It doesn't say employers shall make no law or make no rule or make no handbook provision. It says Congress shall make no law, which has really been interpreted to mean the government shall make no law. So the First Amendment is really, of course, about government in some way trying to infringe on a person's free speech rights. It's not about private employers. Private employers are not the government, and they are not restricted by the First Amendment. And state constitutions can vary a little bit. It's always important to figure out what state you're dealing with, where your employee works, and looking at those specific provisions. But for the most part, state constitutions are very similar. They limit the state government's right to, restrict a person's free speech, but they don't restrict an employer's right. So if you're ever asked, does an employee have free speech rights? Well, they don't have them under the First Amendment unless you're a public employer. So let's go forward. So do they have freedom of speech? Well, if you are a public employer, if you happen to be a federal government agency, a state government agency, some other public employer, Usually those entities are considered part of the government. They are state actors for purposes of the Constitution. And so those particular employers, public employers, are limited by the First Amendment. It doesn't mean they're completely limited. There's always this balancing between, being an employer and having an effective workplace, and yet employees having some right to free speech. So there is a balancing that goes on there, but at least you know that if you're a public employer, the First Amendment applies, and it's going to be a little trickier analysis. But if you're a private employer, you're not part of the government, you're just a company, you're not a state actor, and you're not limited by the Constitution. You don't have to worry about the federal or state Constitution, at least in that scenario. But, always a big but, right? There are other limitations that we have to think about. And so we always have to ask. One of the first things I ask, if you've ever called me with a question about some issue you're dealing with as an employer, one of the first questions is, where is the employee located? What state are they in? Because we have to look at the state law. If they're in Utah, we'll talk a little bit about what sort of restrictions exist in Utah. But if they're somewhere else, we're going to have to look at that specific state law. And a number of states have laws that basically say an employee has a right to free political speech, and they have a right to engage in lawful off-duty activity. If they're not at work, if they're on their own time, they can do something as long as it's lawful. And you as an employer don't have a right to get involved with that. So states like California, not surprisingly, Colorado, New York, North Dakota have these sort of provisions, and they all vary a little bit, not constitutional, but statutory provisions. So always think about what state you're in. Utah also has a fairly new free speech statute that we're going to go into in some detail, and think about maybe how that impacts our ability as employers to limit an employee's right to free speech or to political activity. And then beyond that, looking at state law, which we'll talk about, you also have to think about federal discrimination statutes. Are there any of those coming into play with the speech issues? And also the National Labor Relations Act, which has some limitations on how much an employer can impact an employee's right to free speech. Okay, so let's start with state law. We're going to obviously talk about Utah today. We can't cover all 50 states, so let's talk about let's talk about Utah. And I think it's a pretty good example of what a state might do with this whole concept of does an employee have a right to free political activity? So the second question I always ask if you call is, how many employees do you have? And we have to know that for a variety of reasons. There's all of the laws in employment are all geared on how many employees you have, and they kick in once you have a certain number of employees. And you probably know that with the Utah Anti-Discrimination Act, as with most federal anti-discrimination acts, it kicks in when you have 15 or more employees. So if you have 15 or more employees, the Utah Anti-Discrimination Act applies, and it has all the normal provisions that we think of. You can't discriminate based on someone's gender or their race or those sort of things. But in 2015, an extra provision was added to the Utah Anti-Discrimination Act that specifically deals with political behavior and with speech. And this was sort of called the Great Compromise. And what was going on in 2015 was that the federal government hadn't really recognized the rights of gay individuals and transgender individuals in terms of anti-discrimination. But there was a movement in Utah to try to add those to the Utah Anti-Discrimination Statute. And there was basically this compromise between activists for the LGBTQ community and for the LDS Church in Utah to work out a compromise on this issue. And that's exactly what they did. So this was the Great Compromise. And what they did is they added sexual orientation and gender identity to the anti-discrimination statute, so that those are protected classes in Utah. But in return, They also said that employees still have a right to speak freely about these issues. Some employees maybe won't support, you know, sexual orientation rights or gender identity rights, and so there's some freedom of speech. So that was the compromise, recognizing these categories, but also recognizing free speech around these categories. And I add this question here, isn't this compromise still required? And the answer really is no. If this were happening now, this compromise wouldn't have been required, because basically those categories have been recognized by federal law, and so we don't have to recognize them by state law. But that statute was passed in 2015, and it's part of the law. So what does this say? What does the Utah Anti-Discrimination Statute say about freedom of speech and political speech? Okay, so there are two parts of the statute that you have to know. And the first part, section 1, is about speech in the workplace. And the second part, section 2, is about speech outside of the workplace. So it's all in Utah Code 35A-5- section 112. And it's called the Religious Liberty Protection Statute. And this is just the heading: expressing beliefs and commitments in the workplace, prohibition on employment actions against certain employee speech. Okay, so we kind of know what the general category is. So let's look at section 1 that talks about freedom in the workplace. So section 1, an employee may express the employee's religious or moral beliefs and commitments in the workplace in a reasonable, non-disruptive, and non-harassing way on equal terms with similar types of expression of beliefs or commitments allowed by the employer in the workplace, unless the expression is in direct conflict with the essential business-related interests of the employer. There's one sentence, but there's a lot of stuff packed into that one sentence. And one thing I should tell you before we start talking about this is that this statute has not been interpreted by the courts. Utah courts have not had the opportunity, or have not taken the opportunity, to tell us what this statute means. And there's a lot of sort of vague terms floating around in here. And so a lot of uncertainty. But the big thing you need to know as an employer is, if there is an issue about political speech, about morality speech, we have to be concerned that this statute might apply, and we have to know, yeah, there's a question mark. I need to examine this question more carefully. So if we break this down a little bit more, it does say an employee has some rights to speak about what? This is in the workplace. It says religious or moral beliefs and commitments. Religious or moral, what's encompassed in that exactly? We don't know. It hasn't been interpreted. I think we pretty much know what religious is. What is moral? Moral could be pretty broad, it seems like. It's specific that it's in the workplace, but then it goes on to say that the speech or the expression has to be reasonable. So what's reasonable? Probably not talking about it all day long and not doing your work. That's probably not reasonable. It says non-disruptive. Probably running around screaming about your beliefs is probably not going to be okay. And it has to be non-harassing. So it can't be something that then infringes on someone else's right to be free from harassment. So this is really complicated, right? There's a freedom to talk about religious or moral beliefs, and yet I can't harass somebody else. So if I'm making a lot of comments about religion, and that's starting to infringe on someone else's rights, negative things about their religion, that could be problematic. And then it goes on to say that employees have this right on equal terms with similar types of expression allowed by the employer. So what seems to be going on in the statute is that it seems to be saying that if the employer allows some type of speech, similar types of speech, then they have to allow everyone to have a similar type of speech. So if I let people talk about religion, I probably can't say, well, people of this religion can speak about their religion, but other people cannot. I've opened the door basically to that category of expression. So that's an interesting concept. It means as employers, we probably have some right here to either say, yes, we're going to open the door to some speech. And if we do, we have to allow it, similar types of expression. And if I want to shut the door and not let anyone speak about that topic, I probably need to make sure that I'm pretty careful to do that equally. So that's the concept that's there in that statute. And then it also goes on to say that basically an employer can limit speech if it's in direct conflict with the essential business-related interest of the employer. So if the speech is somehow conflicting with my business interests, and again, we don't have an interpretation of this, but you see this a lot with the cancel culture. If my customers are all getting very upset about something an employee has said, and they're coming forward and they're complaining and we're going to lose business, maybe that's in direct conflict with our business interests. For example, if I had an employee who went out on social media and said that they had some moral belief that was racist, there might be people who would be very upset about that and say, you need to get rid of that person. They're being racist. And I might say, yes, my customers are upset about that. That's in conflict with our business interests, and we need to deal with that. So that's in the workplace. If you aren't confused enough, let's go on to the next concept, which is what can an employee do outside of the workplace? And this is section 2. And what section 2 says is that an employer may not discharge, demote, terminate, or refuse to hire any person, basically take a job action against them or retaliate against them, because someone who is otherwise qualified for lawful expression or expressive activity outside of the workplace regarding the person's religious, political, or personal convictions, including convictions about marriage, family, or sexuality, unless the expression is in direct conflict with the essential business-related interests of the employer. So in section 2, we know we can't take action against someone for their speech outside of work if it's lawful. First, it has to be lawful, right? And it has to fall in one of these categories. It has to be religious, political, or personal. Well, that's probably about everything. And notice it's a little bit broader than the section about what's allowed in the workplace. I don't know if that's intentional or if that's just kind of how the sausage was made, but the section talked about political or moral, right? I think it was political or moral. And the second one talks about religious, political, or personal. So quite a bit. I mean, personal, you would think, would cover about everything. So if it's lawful, if it falls in one of those categories, they're allowed to do it without having any sort of action taken against them. Again, unless it's in direct conflict with the business interests of the employer. So if you want to say you want to take action against an employee for some sort of political activity or free speech activity they engaged in outside of the workplace, you're going to have to be able to say that this is related to your business interests. So we know whenever these issues come up in Utah, at least, that we have to be concerned about this statutory scheme and what it means and what action we can take. And you're probably going to want to analyze that carefully and document it internally if you decide to take some sort of adverse action. So that's the Utah statute, which is so interesting. But let's move on a little bit and think about this. So can an employer require an employee to remove one of these bumper stickers from their car? I'd like to sort of think of this as an example. And I kind of looked around for other things employees might display in the workplace. So they might have an RBG doll. They might have a Trump doll. They might have just an innocent looking donkey. All of these things and bumper stickers we have to think about. Are those allowed? Or as an employer, can we tell them that they have to take those down? So let's think about the bumper sticker, and someone comes to work and they have the bumper sticker. Maybe they have it on their car, maybe they want to bring it in and put it in their workspace. And we have to go back to that first statute, right? The first part of the statute, which is, are they allowed to do that? Section 1, and we know that they're allowed to do that if we allow other similar type of speech, and if it's non-disruptive and it's non-harassing and it doesn't conflict with our essential business purposes. So if we're going to allow some of these bumper stickers, we probably have to allow them all. That's what the statute in Utah tells us. And if we want to ban them all, we probably can ban them all, but we have to think about that up front. What do we want to do? Unless there really is a business interest that's coming into play. And I had one client bring this up at another seminar I was doing, and that is that they run a newspaper, and newspapers are supposed to have this public image of neutrality, right? And so they don't want their employees coming to work and parking in the parking lot and having bumper stickers that suggest that they're not neutral, but take a position on issues. So that employer, because of their unique business, might have a business interest in even preventing employees from having that sort of thing on their car if it's in a parking lot at work. So we always have to think about, what does our business do? What are our business interests? You know, what's appropriate to limit or not limit? And if we are limiting something, are we doing it equally? Okay. So another thing we have to think about is discriminatory conduct. So we always have to be concerned about all the anti-discrimination statutes and whether certain kind of speech, political speech, is potentially infringing on someone's right to not be discriminated against because of their race, their religion, their gender, all the things that we know are protected under the law. And the best example I have of this that has come up in the last couple of years is associated with the Black Lives Matter movement. And you probably heard this story on the news. And that was, right when a lot of the protests were going on, a number of employees wanted to wear Black Lives Matters, stuff at work, maybe t-shirts, maybe masks. In this unique environment we have the last year and a half, a lot of it was masks. And the one situation that went all the way to court was for Whole Foods. So Whole Foods had a policy that said employees couldn't wear masks or t-shirts or hats that had any sort of logos. They could only wear Whole Foods logos, right? So a lot of companies have that kind of policy. That makes sense. You can wear Whole Foods t-shirts, you can wear Whole Foods hats, you can wear Whole Foods masks or plain ones, but you can't wear other ones, including, they said, Black Lives Matter. And there were a number of employees who supported that movement, wanted to show that they cared about Black Lives Matters, and so they wanted to wear those kind of masks. But Whole Foods said, no, that violates our policy, and it went to court. The employees said that this was violating their rights as part of a racial protection because they were expressing their support for Black lives. And the court, this was not in Utah, I can't remember the specific court, I think it was back east somewhere, ended up saying that it just didn't go far enough to implicate race as a protected class, that Whole Foods was really just trying to protect their logo and their image, and they didn't want to open the door to other kinds of speech, right? Because that's the risk. Think about if this was Utah. If this was Utah and you allowed people to wear masks or t-shirts that said Black Lives Matter, you might be opening the door to similar types of speech that could be very different than that, but similar. So that the court ended up saying that was not protected, but we always have to think about that. If the political speech is touching on issues like race or religion or sex, we have to be careful. If it's one of those protected classes, we have to think about, is this discriminatory in any way? Are we infringing on somebody's rights? So that's also a concern when we talk about these sort of issues. Okay. All right. So when we're thinking about that issue, it's really, really important that we have good policies, anti-discrimination policies and anti-harassment policies. We should have those no matter what, but as we're thinking about political speech and free speech, it's a really good time to look and make sure that we have good policies on these sort of things, that we make sure that we're protecting people from that harassment that the statute talked about, that, even if we allow some political conversation, we're making sure that it's not offensive, and that if it is offensive, that people have a procedure for coming forward and making a complaint, so we can look into that and consider, where political speech is protected and where is someone's right to not be harassed protected, and are those two coming into conflict? So always important, but also important in this area of political speech. And it's always because we have the risk of discrimination claims. When we allow political conversations in the workplace, those political conversations oftentimes can be about things about like gender and race and religion. All of those things have been very big in the news lately. And if those kind of conversations are coming up, they might be in violation of Title VII. So for example, someone might say, my supervisor is biased against women because they made certain political comments about the rights of women. Or maybe they'll say that their supervisor is discriminatory against Latino people because there were certain political comments, maybe political comments regarding immigration policy that appear to be offensive. And this kind of leads to the concept about, what we allow our supervisors to do can even be more problematic than what we allow the rest of the workforce to do, because supervisors, of course, have power, and they can be viewed as having, a lot more power than everybody else. And so we have to be careful about what they say. So, and another thing to keep in mind here is that employees have free speech, let's call it, to come forward and make a complaint. They always have a right to make a complaint about Title VII issues, about discrimination or harassment. So even if we have allowed political speech to some degree, we need to make sure that people can make complaints about that speech if they think it's encroaching on their rights. Okay, next slide, Jason. Now, the final area that I want to talk about that creates some area for free speech for employees is the National Labor Relations Act. And probably many of you are very familiar with that, and others maybe haven't even heard of it or are not that familiar. The National Labor Relations Act was passed a long time ago, I think in the 30s or 40s, to really provide some protection for people who were organizing in the workplace, creating labor unions, trying to improve working conditions. And even though that is the genesis, it does go beyond labor unions. And you should never think that just because you don't have labor unions in your workplace, that the National Labor Relations Act doesn't apply to your workplace, because it does. It does apply. And the National Labor Relations Act is governed by something called the National Relations Labor Board. And just like Sean and Liz talked about in the last session, that board changes with every presidential administration. The president gets to name the people who sit on those boards. And so the policy is impacted a bit. But the National Labor Relations Board enforces the National Labor Relations Act. And one of the things they enforce is something called Section 7 rights. And under Section 7, employees have the right to talk about their wages, their hours, their terms and conditions of employment. They have a right to talk about those things together and support each other and complain about them and try to change their workplace. And this could potentially give them the right to engage in some sort of political speech. And again, remember that this applies regardless of whether you have a labor union in your workforce or not. All employees have this right. Okay, so we can go to the next slide, Jason. So Section 7 in particular talks about the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities. So that's the free speech for the purpose of collective bargaining or to provide mutual aid and protection. So if we all want to just complain in the workplace about wages, or we want to complain about how our supervisor is a jerk, those sort of things we're allowed to do. The National Labor Relations Act protects that kind of speech if it's about working conditions. So this is the final area that we have to keep in mind. Let's go to the next slide. So this could be things about pay, it could be about benefits, it could be about workplace safety, it could be anything that's the term and conditions of employment. It can't go so far that it disrupts business, just like anything else. You don't have to put up with it disrupting business, but employees are allowed to talk about these issues to some extent during work, as long as it's not disruptive or preventing from doing their job, and definitely outside of work. And definitely in work, if you allow other types of speech, if you let people at lunchtime go in the cafeteria and talk about whatever they want, you can't tell them that they can't complain about working conditions. They're allowed to do that, which is another reason we have to think in advance about how much freedom we're giving people. Because if we open the door about some topics, we're probably opening the door to other topics. But it does have to have, in terms for the National Labor Relations Act to apply, it does have to be connected to working conditions in the workplace. So just generally talking about politics wouldn't be protected. But if I'm talking about politics and how I think Congress ought to pass a particular law to protect employees from workplace safety concerns, and I'm concerned about workplace safety at my work, then that particular political speech has now become about the workplace, about working conditions, and that's going to be protected. So when these issues come up in your workplace, you have to think about, is this something where the National Labor Relations Act might protect this speech? You have to be concerned about that. So we talked about the Utah statute, and you always have to think about what state you're in and what statutes might apply. We talked about discrimination statutes and how those may come into play. We talked about the National Labor Relations Act. So one thing employers have to think about is, do we want to just have a no politics policy? Do we want to just say people can't talk about politics at all? Because if we do that, we can, as long as we do it even-handedly, we probably can do that. And some employers decide to do that, no politics at work. If you do that, though, at least in Utah, you have to be careful that you're doing it even-handedly, because that statute, which has not been interpreted, seems to say that if you allow one type of speech on a topic, you probably have to allow other types of speech. So that's something you need to be concerned about, unless it conflicts with the direct, the direct interest of your company. And you have to think about different kinds of companies. For example, if someone works at Planned Parenthood, there might be certain types of speech that are problematic and other types of speech that aren't problematic for that particular company. Or if you work for a gun manufacturer and Second Amendment rights are very important to that gun manufacturer, maybe some speech is in direct conflict with your business purpose and others are not. So there can be companies that are sort of inherently political, but others that are not. But I always ask this question to companies when they think about, are we going to just have a no politics policy? And that is it realistic? If you're really going to have that policy, are you going to enforce it? Are you going to enforce it even-handedly? Does it even make sense? Some employees are just not going to put up with that. They're not going to, not talk about politics at work. So you have to think about that, because it's not good to have a policy if it's not going to be enforced, if it's not going to be realistic. So this might be an option for your company, and you should think about it. But it might not be. It might just not be realistic. And with the labor shortage we're having right now, of course, thinking about what's realistic and what employees are going to expect or not expect is important. But at least before you think about anything else you might want to do in this area, you ought to think about that. Is that something you want to do? Have a no politics policy or no? And then know what the repercussions are going either way. Okay, so that's sort of the first practical tip, talking about no political activity. But again, we have to have some exceptions. For example, employees are allowed to talk about political activity if it impacts National Labor Relations Act right. So if you had a policy like that, it would have to have an exception for Section 7 NLRA rights. So if an employee wants to talk about political issues that impact working conditions, they would have a right to do that. So that's something to keep in mind. Do we have any questions so far, Jason? I can't really see the Q&A.
Yeah, Christina, one question came in earlier in the presentation, and it's related to the differences, obviously, between public and private companies. And so here's the scenario. If a private employer received government funding through a grant, is there any implications on First Amendment free speech?
It depends on what that grant says. So the really critical thing in that situation is to look at your grant and look at any contractual obligations you have with the government, because that is another area where you could limit your own speech, which is your own ability to limit employee speech is by taking government money or entering into a contractual relationship with somebody else where you agree basically that you're not going to do something. So you're going to want to look at that grant and see if you agreed that you would do anything. It could be you would do drug testing, or you agreed that you would require vaccinations, or you agreed that you wouldn't limit political speech to some degree. So look at your grant, look at your contracts. Hopefully
Great,
that
thank you very much.
Yeah, let me know if there's any more questions about that. Any other questions, Jason, so far?
Nope, we're good. Let's proceed.
So another practical tip in this area about politics in the workplace is to look at your social media policies and look at your IT policies. You can, of course, tell employees what they can and cannot do on your own social media or your own IT resources. So, for example, you can tell employees when they're using workplace social media, or they're using their work email, or they're using a work phone, or they're using a work network, that they can't talk about politics, or they can't talk about racially discriminatory issues, or that they need to keep it completely professional, only talk about work issues. That is absolutely allowed. But, remember back to that Utah statute. If you open up any of those resources to some issues, to some free speech, you might be opening it up to everything. So you certainly could say the company email can only be used to talk about, workplace business, or you could say, well, no, you can also talk about social issues. But if you do that, you're probably opening it up to all kinds of opinions on social issues, which you may or may not like. So again, think about that. Do you want to limit how your social media is used? Do you want to limit how your email is used, how your network is even used? You can have rules that say employees cannot come to work and use their workplace networks to get onto their own private Facebook account and make certain statements. But you probably need to do that even-handedly, either not allow it at all, or if you're going to allow it, it's probably going to have to be pretty handed. So you have to be careful about that, and you have to think about that. But you certainly should have policies that say employees cannot use any of those resources to engage in discrimination or harassment or anything like that, because you should be outlining that no matter what. And again, you always have to think about the National Labor Relations Act and Section 7 rights. You don't have to let employees use those resources to complain about working conditions, but if you open it up at all to personal sort of issues, then you probably have to let them talk about that. Now, if someone sent an email to their supervisor complaining about wages, you would never want to discipline them for that. That would be protected by the National Labor Relations Act. So just another area we can think about, we can use to make restrictions, but we also have to be careful. You've probably noticed that all of these things are pretty tricky, that you can't just jump in and do whatever you want. You have to think about, about the balancing of all of these issues. Okay, Jason, we'll go to the next slide.
Yeah, real quick question before we advance to the next slide. What if an employer reimburses an employee for personal cell phone usage? What limitations can an employer set?
Yeah, so the question, if I think I heard it right, is what if you just reimburse employees for their phone? So it's their own phone, and they own it. They are allowed to use it for personal things, but you reimburse them for the expenses. But you've got to think from the outset about what your policy is going to be. If you pay for their phone, if you pay for it 100%, maybe you'll have a policy that says they cannot use that for anything personal, that that's just for work purposes. If you open it up to anything personal, then it's probably going to be pretty difficult to restrict how they use it personally. If you open it up, what are you going to say? They can do these things personally, but not other things? That's going to be pretty difficult. So if you really want to have control over how employees are using phones, it's better to just have the employer purchase the phone and limit the phone just for work purposes. If you're going to let them use their personal phone and just reimburse them, it's never probably going to be 100% reimbursement. Then you're probably opening them up to having some personal use of that. Hopefully that answers your question. Great, thanks, Jason. Okay, so as we talked about, if you have policies that do permit some workplace discussions of politics, of candidates, of issues, you are opening the door, but it is important to let employees know. You can at least have a policy that says they have to comply with all other workplace policies if they're having those discussions, which means they have to comply with anti-discrimination policies. They have to comply with anti-discrimination policies. You could also, even if you open up that kind of workplace discussion, you can still insist on respectful treatment, no discrimination, no harassment, no retaliation, those sort of things. Although I have to put an asterisk next to respectful, because the National Labor Relations Board has been very clear that employers cannot tell employees that they have to be respectful in complaining about workplace conditions. You cannot say, oh, you have to be respectful, and then an employee is very upset that they don't think they were paid enough, and they tell their employer, they talk with other employees about how their boss is a big jerk, and maybe they use more colorful language than that, because they're not paying them appropriately. The National Labor Relations Board is going to say there's a pretty wide protection for employees having conversations about those issues, even if there's something that you probably don't think is that respectful. And again, if you limit political expression, which you could, because it impacts productivity, it impacts customers, it disrupts work, you could do that. You have to do it even-handedly, at least in Utah. But if you're going to do that, I would suggest that you limit it to things that truly are impacting the workplace, that you not try to venture into things that aren't impacting the workplace, that is really where the employer has the most power and the most right to do that. And then, of course, if you're going to do it in the workplace, because of the Utah statute, you probably have to do it even-handedly, unless there's something about your business specifically that suggests that not doing it even-handedly might make sense. And we'll talk about that in an example in a minute. Another thing that a lot of employers do, sort of a practical tip, is to outlaw solicitation in the workplace. So sometimes companies just say you cannot solicit each other in the workplace. That means you can't ask each other for campaign contributions. You can't ask each other to support Girl Scout cookies for each other, just non-solicitation, no political campaigning, none of that. Again, the problem with that is that usually we don't want to do that even-handedly. Usually we want to allow some, but not others. And if we allow some, we're probably opening the door to other types of solicitations. So, if we want to let people ask each other to support each other's Girl Scout cookies, we might be opening up other solicitations. So just think about that and what you want in your workplace. Do you want to limit that? Which could be a good idea, because a lot of people don't want to be solicited in the workplace. Or you could limit it to one venue. Maybe there's one bulletin board or one place on your electronic bulletin board where people are allowed to put those sort of solicitations, but not in other places, so that it's limited in some way. Okay, and on practical tips, it's important to remind managers and supervisors from time to time that they should avoid political conversations with their subordinates, because it can cause a lot of problems, right? If their subordinates think that their bosses, their supervisors are basically telling them what they have to think or what they have to do. That can be problematic. Okay, next slide. And also remind managers that if there is a complaint of any sort, even if it seems to have political overtones, that they should bring that forward to HR, because HR is going to have the tools to think about all these complicated issues, right? How the Utah political free speech statute comes into place, how anti-discrimination statutes come into place, how the National Labor Relations Act fits in. These are really complicated issues. They're not simple. There's no black and white answer. So it's important for managers to bring these issues forward to HR and let HR deal with all the nuances of the law. And also to remind managers to be as even-handed as possible about things like dress code, about things like non-solicitation policies, because the place where we get in trouble is when it's not consistent. And I'll give you an example from that Whole Foods case. Remember, Whole Foods wanted just the company logo used, and they didn't want people to be able to wear Black Lives Matter, t-shirts and masks and stuff. But when that went to court, the proponents of BLM rights, what they were saying is that had not been enforced consistently. That Whole Foods had sometimes let people wear things about their favorite football team or their favorite baseball team, that there had been slips basically in the policy. And then there was an argument that maybe the company had opened the door. Now, that wasn't ultimately successful, but you don't want to be in that position. So if you're going to have a dress code that says, no wearing logos outside of the company logo, then you've got to do that consistently. If that's your policy, which you can choose to have or not have, then do it consistently and make sure that one supervisor isn't basically opening that door in some way. Or if you're going to have a non-solicitation policy that says we don't allow any solicitations in the workplace, we don't want one supervisor that says, yeah, well, I'm going to let people solicit for this one anti-cancer campaign that I really support, and then potentially you open the door to other types of similar solicitations or similar speech. So we need to think about that in advance, and also reminding managers that as they're enforcing these policies, that they shouldn't be impacted by their own political views, their own political activities, that they have to enforce the company policy, whatever you've decided it's going to be, and enforce it consistently. When we have a particular something coming up, if it's a campaign, if it's an election, if there's something where there's going to be a lot of activity, there's going to be potentially a lot of discussion, we need to talk about respectful work environments. We need to talk about, not crossing those lines into something that can be discrimination or harassment. We just need to be super aware during these political times that those sort of things aren't crossing the line and crossing into somebody else's right to be in a work environment that doesn't discriminate or harass. So keep that in mind as well. And if you ever get into one of these really tricky issues where there is political speech or free speech, but you think is problematic for the company, and you want to discipline an employee or fire an employee because of their political speech, because of their political activity, hopefully, if nothing else, this conversation has made you aware that there's a lot going on here, that they might have some rights under the Utah statute to free speech. There might be a right of other employees in the workplace to not be harassed or not be discriminated against. So it's complicated. And you should talk to your in-house or outside counsel if these sort of issues come up, to make sure that you're doing the best thing you can and that it's being documented very carefully to not get you in legal trouble. I think we're coming really close to being out of time. So I have a scenario at the end. How much time, do we have any time left, Jason?
We have 1 quick minute.
Okay, 1 quick minute. So this scenario that I've included, you might want to look at it in your own time, but it's basically about someone who is exercising, political speech, but the employer's concerned that it has gone too far, maybe is unlawful, maybe is impacting their customers, and they have to think about what they want to do with that. And it raises a lot of the issues that we talked about today. So I don't think we have quite time to go into that, but please contact me if you have any questions outside of this discussion today, since we didn't get to really interact too much, and I'm happy to discuss it with you. Thank you so much. I appreciate your time.
Hey, Christina, thank you very much. We really appreciate you being with us today. Great tips, great guidance on what is clearly a very delicate and complicated issue. So thank you so much for sharing all of your information with us today. Okay, we are in the 7th inning stretch. Our next presentation will start at 11 a.m. today, and we're going to wrap up today's presentation talking about internal investigation. So we'll give you a 5-minute break, and we'll kick off the final session, or the final presentation rather, at the top of the hour. So see you at 11.